Hi, I'm Rahul Ravipudi, and I'm lucky to be here on her birthday with my partner, Erika Contreras. We're at the law firm of Panishay Ravipudi, and we're having a CAOC conversation. And we're going to talk a little bit about advocacy and the joy in getting to represent our clients, which is something we are very proud of. And so, Erika, tell us what brings you the most joy or fulfillment in the job that we do?
So there's a lot of phases of joy when you're litigating a case. First, when you meet the client and you feel that you can really help these people, they're in a terrible time in their life, and you want to help them, and you're starting to kind of make a path to be able to do that. My favorite part of the case is when the case resolves, and you get to tell them that they don't have to deal with the stress of the litigation anymore, and you can actually visibly see a lift in their body and their response, either when the verdict comes or when the case resolves. It's just something terrible has happened to them, but they keep reliving it throughout the litigation, and it doesn't really go away until the litigation is over. So I really love that part, just being able to lift that from them.
So let's take a little step back. There's so many areas of law that we could choose to practice in. Why did you choose representing people who were injured in corporate negligence and public entity negligence?
I think that it is a very common thing amongst all plaintiffs' attorneys. We want to help people. We want to have this interaction with a person. A lot of our clients they don't have resources. They don't have the background or the understanding of what's happened to them and that it's wrong. And so you get to really uplift somebody at a terrible time in their life. And it's an individual, it's a mom, it's a dad, a child. And that's really the reason why I came into plaintiff's law and then stayed in plaintiff's law. I mean, what about you?
Yeah, it's exactly the same. I had the opportunity, and I actually went to law school thinking I was going to be an environmental lawyer, found out it was all about regulatory work and not quite as exciting as I thought it could be. Then I started working at the Ventura District Attorney's Office, where, as you know, I famously am undefeated, 100% conviction record for fishing without a license, and then got the opportunity to work at an amazing firm with Panish, Brown Green, Bruce Broilette, Jeff Wells as a law clerk, and that was my first exposure to representing individuals who were catastrophically harmed or lost loved ones due to corporate indifference. And once I saw it and I saw how much we could do, there was no looking back. And I love what I do so much. I got to tell you this one little story. So my wife, as you know, Smitha, is in healthcare. Used to work at Children's Hospital Los Angeles and now over at USC Keck. And we were in the car with our three boys. This is probably 8 or 9 years ago. And there was just this conversation happening, and Smitha says to the boys, "I feel like you don't even know what we do for a living." And one of my sons responded, he goes, "I know what you do. Mom, you work at a hospital, and Dad, you help people." And I thought, well, it didn't make Smitha happy at all that that's how they characterized her role. But it was really cool to see that they see my job in the same way that I see my job. And it really is something where I've looked at it, and I've looked over the years at all of the big corporations we've gone against, all of the amazing lawyers with amazing billable hourly rates that these corporations can pay, these insurance companies can pay, and these individuals that we represent, they don't have the means to fight against such large corporations. And so then I started doing a little research about it and looked a little bit into the Seventh Amendment right to a jury trial, part of the Bill of Rights in the United States Constitution. And there's a reason why that came about, and the reason is simple. There is a fundamental concern of abuse of power in government. There's a fundamental concern that the powerful get to control the powerless. And the only evening playing field of that is a jury trial, a jury of your peers. And that's the genesis of the Seventh Amendment. And anytime there's an attack on the Seventh Amendment and the right to a jury trial, it's an attack by the powerful against the powerless. Anytime there's an opportunity to take away rights of the powerless, the powerful are always going to do it. And so, that's a transition and an intentional segue to what's recently happened with the Uber initiative and Uber coming out and doing an initiative which limits personal injury victims' ability to seek medical care, limits their ability to recover for the expenses incurred as a result of corporate negligence, and limits their ability to hire lawyers. And so what are your thoughts on that, and how does that make you feel?
It makes me upset. It makes me very angry. And the reason for that is because it's really re-victimizing the victims. Something's already happened to them. They're already in a terrible state. And then you cut them off at the legs. You can't hire a good attorney. You can't, prosecute the case. These cases, especially against huge corporations, they tend to be expensive. You have to fund the depositions. You have to get the experts. And if everything is limited, how good of a job can you do for these clients? And so it does make me very angry because a lot of the cases that we see, they're incidents or accidents that should have never happened. Somebody screwed up, somebody wasn't following corporate procedures, somebody put profit over safety. And so, these events are events that were going to happen because corporations don't care about people, they care about profit. And so, I think it's very important for people to understand that victims need someone to advocate for them. And that's really what plaintiffs' attorneys do, is we advocate for the victims. And it is very much a David versus Goliath scenario. And you can't cut off David at the knees and then still expect him to win against Goliath.
Yeah. Now, in our cases, and I know you've done this so many times, and it's part of really the firm culture, we want to do the best for our clients, hold the defendants accountable, and get full and fair, just compensation for our clients. But if tomorrow we could have a situation where every corporation acts safely and responsibly and people don't get hurt, how wonderful would that be? What do you do on some of your cases where the opportunity presents itself to do the best for our clients, but also maybe implement some sort of level of prevention so things like that don't happen again to other innocent victims?
So I didn't know this was a thing. But when I came to Panish and I started seeing some of the work that we were doing there, the fact that there are non-monetary terms that can be incorporated into a settlement was amazing to me, because we typically think that the way to help a plaintiff is to, award them damages, monetary for loss of income, medical bills. But the first case I ever saw where this happened was Lee versus Whittier Unified School District. That's a case that you guys handled, that your team handled. And to change the way things happen so that this never happens again, I mean, what better way of having a conversation with your client and saying, I'm sorry this happened to you. Yes, you were able to obtain a settlement, but you have now made sure that this never happens to another family. I mean, how was that conversation with the plaintiffs?
I mean, it's amazing, and part of it is a lot of our clients, they want accountability, and they believe the best way to hold somebody accountable is for that defendant to actually take steps so that it doesn't happen again. And in Lee versus Pupil Transportation Co-op and Whittier School District, that was a 19-year-old nonverbal autistic young man who was being bused to school, and the school bus driver on a hot September day got a text from his mistress and decided not to drop off Paul at school, drove right into the school bus parking lot and left him there. And Paul, being nonverbal, he doesn't do anything unless he's told to do it. So he sat on that bus and sat on that bus and then ultimately died of hyperthermia. And what ended up happening from that case is we came to learn that Paul's not the only kid that's been left on school buses. There's laws and regulations about what bus drivers need to do. They need to sweep the bus before they actually leave the bus because kids sometimes don't want to go to school. Sometimes they fall asleep. And sometimes there's kids like Paul who won't do anything unless they're told to. So you just need to make sure it's clear before you leave it. So we worked with the senator, and this is such a great thing about even CAOC, is that implementing legislative change. And so the Paul Lee Bus Safety Act was enacted into law. And what that does is requires that every school bus has an alarm on the back of the bus. As soon as the bus driver turns off the bus, the alarm goes off, and there's only one way to turn it off, for the bus driver to manually walk back and physically push a button to turn it off. And that requires the bus driver to do what they oftentimes don't, and actually sweep the bus and make sure that nobody's left behind. And that's actually led to significant prevention, not just in California, but other states have started implementing that, and buses and school buses in particular are now safer for kids all across the country.
Yeah, I think that a lot of people believe that if a corporation has an incident happen or a company has something wrong happen that results in an injury, that they look at the situation and they on their own think, oh, let me change this, let me do something different so that it doesn't happen again. And that's just not the way the world works. And it's really organizations like CAOC and law firms like Panache Ravipudi who come together and force these corporations to change their ways, change their policies to make sure that this doesn't happen again. They don't do it on their own. It's really a meeting of you're either going to do it or this case is going to go to trial. And that's how change really happens. And it's interesting because most people don't know that. And I do think that that's one of the best scenarios in a case when it resolves, and it leads to long-term change.
Yep. Another thing is why, this has always bothered me and I never understood it, but so many defendants don't take the opportunity when they do something wrong to just reach out to the family and say, I am sorry. That actually has significant value to a lot of people. And I think about the Alex Pierce case. This is a 14-year-old boy at an end-of-the-year school party that was held at the high school, and it was lifeguarded. It was a school event, and while he was there, it's all on video. It's very tough to watch, but Alex got tired in the pool. He was waving for help. He waved for help 7 or 8 times, and then he went under. And then none of the lifeguards went and tended to him. Finally, other students pulled him up, and then the lifeguards intervened. Alex was without oxygen for about 9 minutes and then ultimately died. And the school could have just reached out to the family and said, I am so sorry. Instead, they went on a spin machine, put out a press release talking about how it wasn't their fault, and then the family reached out. And they said all we wanted was for them to say, I'm sorry.
Yeah.
And then ultimately litigation ensued. They were held responsible. And then further remedies were done on the non-monetary, which is we required that the school district actually do an evaluation of their emergency safety plans and then evaluate exactly how effective it is, CPR availability, everything, AED devices, and then they broadcast that, the results of that, so that every other school district in the state of California can learn from this, learn from a professional evaluation, and be introspective and say, hey, do we have these things? And if they don't, get them. And then Alex Pierce, the School Safety Act with Alex Pierce was done as well. Legislation was done because, shockingly, you were not required to have anybody CPR certified at a school. How is that even possible? And so, to get your teaching credentials, you need to be CPR certified, but there's no requirement that you maintain your certification. And so the law that CAOC and we were able to help get implemented makes it available so that There are now more requirements for CPR certification in schools, so somebody could have saved Alex, who was competent and available. And it encourages all of the school teachers to get their recertification, which would be paid for by the government. So there's yet another opportunity to save lives, which I think is so important.
Yeah, and one of the things I'm so proud of is at the firm, a lot of our non-monetary settlement terms involve school districts, involve children. And I mean, I'm a parent, you're a parent. It's so important because these children cannot advocate for themselves. And when they are at the school, they are at the mercy of whoever is supervising them. We handled the case of Adeline Sepulveda against the Yucaipa Mesa Joint Unified School District, where we had a 14-year-old who died at school during school hours because she had an unmanaged asthma attack. And it's the #1 illness for children. These teachers did not know how to recognize it, did not know how to react to it. Her asthma just kept getting worse and worse and worse until she went into cardiac arrest at school. And like you said, mom just really wanted an apology and to find out what happened. But rather than tell her, look, we didn't know what was happening, we didn't manage it well, and we're sorry, they said, well, I think she had peanuts. She might have been allergic. She might have had an allergic reaction. It's not on us. And that case ended up changing the way the school district trains its teachers. There was new policies implemented to make sure that, shockingly, teachers don't review the medical files of the students that they have. And after this settlement, now they do. They're required to sign off and say, I reviewed, I understand that they have these medical conditions. There was new training, partnership with a local hospital to make sure that the teachers were trained in case medical emergency happened. That makes sure that this doesn't happen again. It makes sure that the chances of another child dying at school because of an asthma attack are severely reduced. And that's great. I mean, I think that made Mrs. Sepulveda the happiest of everything that we did for her.
Amazing.
No?
Amazing. Okay, Erika, over your career as a trial lawyer, what have you seen change in how to advocate for clients, and what have you seen as some of the changes and some of the most effective tools that you've seen that you could share with others?
I think now, video depositions, it used to be something that not everybody did. Everybody now incorporates them into their trial presentation. It is very common for people to play videotape depositions in their case in chief, of the defendant's experts, of the defendants themselves. And it just really facilitates and moves the flow of trial so much easier. Everybody does it now, and I think it's great. I also think that there's just so many women out there now, and I love the fact that I see all these women trial attorneys out there. When I started in the industry 17 years ago, the women were out there, we just didn't see them every day. And these women are out there and they're getting these great results, and I'm just so happy to see that the industry is diversifying a lot. And it's reflected because it reflects our clients. And it's great that the industry is not reflecting the people that it represents.
I love that. I love that. You know, there was a white paper done by the California State Bar a few years ago about the demographics of the California State Bar. And given relative to the demographics of this entire state of California. And over the years, what has been grossly underrepresented in the entire state bar is the Latino community. There's very few Latino lawyers, female lawyers. That has changed over the years, but still underrepresented, minority lawyers in general. And so when you kind of look at it, and what I was trying to do through various organizations is, look, the practice of law needs to be representative of the practice of the community it represents. But it's really hard to do if there's if it's not, in sync with each other. And so we've been reaching out to high schools, and we now do an LAUSD mock trial for 250 kids who come to LA Superior Court to try and inspire students, high school students, to want to get into the practice of law so that we can start at the very root and try to actually change the demographics of the California State Bar. So what you say is so important, and it's so critical, and it is fantastic to see that things are changing and see that people are thriving, but there's more work to do.
So I think CAOC has done a great job in helping in the diversity of the legal profession. The Women's Caucus yesterday was amazing. It's just lovely to see. And so if you haven't joined CAOC or you haven't joined a committee, you should definitely participate because you want to be part of the change, and CAOC is part of the change.
Thanks, guys.
Okay.
Beautiful.
All right.